Yes, good evening to everybody. Welcome to the today class, which I am going to deal the Indian Penal Code, multiple choice questions. Please read what I posted on the screen. Anyone can unmute and read what I posted on the screen. Anyone can unmute and read what I posted on the screen. I repeat. Anyone can unmute and read what I posted on the screen. I don't know why you are not listening to me, but anyway, that I read it. Namaskar, Vargul, Assalamu Alaikum. My online class, that is the virtual classes on the subject, our course, Indian Penal Code, starts India today from 8:10 p.m. to 9 p.m. as a special arrangement on Cisco WebEx platform with my meeting number. Examination date will be announced later as per my knowledge goes. And you are cordially welcome to my virtual class to make the virtual class a success to that to be the 100%. Hosted by Professor Dr. Mohammed Saheb Hussain. Yes, sir. Without wasting the time, let me come to my point of study. That is the All India Bar examination, and the cohort is 17 and 2022 Indian Penal Code multiple choice question. Be ready. First question. The first question: when the Indian Penal Code drafted and submitted to the Council of Governor General of India in the year dash. First option 1834, second option 1835, third option 1836, and fourth option 1837. Which one is the correct answer? Participants, even though it is wrong, you can try. Participant, are you hearing me?
Number 4 is answer, I think.
No, number 2 is the answer. 1835 is the answer. And here I will give the feedback. Who made the Indian Penal Code? Of course, everybody knows. The Indian Penal Code was drafted by the First Law Commission, which was chaired by the Thomas Bevington Macaulay. It was drafted in 1834 and submitted to the Council of the Governor General of India in the year 1835. That is the answer. Next question. Of course, let me see your memory, whether you can able to make it out or not. Second question. The Indian Penal Code was drafted by the First Law Commission, which was chaired by, number 1, Thomas Bevington Macaulay, number 2, Thomas Macaulay Bevington, number 3, Bevington Thomas Macaulay, 4, Thomas Bevington Macaulay. And who is the person who drafted the Indian Penal Code? There are 4 options, I read it. Which option is the correct one?
Serial number 4, Thomas.
Thomas Bevington Macaulay is the right answer for that question. Yes. Let us go to the number 3rd. Indian Penal Code came into force in number 1, 1860, number 2, 1861, number 3, 1862, and the 4th option is 1863. Which one is the right answer? Yes. Among the 4 options, Indian Penal Code came into force in 4 options which I put it there: 1862, 1861, third option 1862, and the 4th option 1863. The right answer is 1862 is the right answer. The right answer is 1862. Feedback, let me see it. It came into force in 1862 in all British presidency, although it did not apply to the princely states, which had their own courts and legal systems. Like Bangalore, Hyderabad, and wherever the princely states are there, it will not be applicable over there. Yes, number 4th question. The code came into force on January 1st, 1860, after undergoing many revisions and amendments by number 1, Peacock Burness, number 2, Burness Pearson, number 3, Butt Peacock, Fourth, Burness Peacock. I repeat the question. Fourth question. The code, means Indian Penal Code, came into force on January 1st, 1860 after undergoing many revisions and amendments by number 1, Peacock Burness, number 2, Burness Pearson, number 3, Butt Peacock, 4, Burness Peacock. These are the 4 options. Among the 4 options, which is the right option? The correct option. Yes. Participants, even though it is wrong, doesn't matter. The fourth one is the right answer, Burness Peacock. For the fourth question, and the fourth multiple choice is the right answer. Next, who was the first Chief Justice of the Calcutta High Court? I repeat, who was the first Chief Justice of the Calcutta High Court? Number 1, Thomas Cook. Number 2, Thomas Brand. Number 3, Thomas Beans. Number 4, Thomas Peacock. Yes. The right answer is Thomas Peacock. He is the first Chief Justice of Calcutta High Court. The code came into force in the 1860 after undergoing many revisions, amendments with the Burness Peacock, and it would be on the first Chief Justice Calcutta. Yeah, the Burness Peacock is the right answer. Burness Peacock is the right answer. Of course, here I did not write. It is Burness Peacock, not Thomas Peacock. It is Burness Peacock. Burness Peacock is the right answer. Yes, next question. Sixth question. Before the advent, I repeat, before the advent of the British, the penal law prevailing in India, for the most part, was the dash. I repeat the question. Before the advent of the British, the penal law prevailing in India, for the most part, was the dash. Number 1, law of Vedas. Number 2, law of Bhagavad Gita. Number 3, Dravidian law. Number 4, Mohammedan law. Before the penal law has come over there, what law is prevailing in India or applicable in India? Participants, doesn't matter, you can make the choice. At least your choice will hit it or not, we will see it. Yes?
Law of Vedas, sir.
Law of Vedas.
No. Mohammedan law was there, prevailing over there before the penal law has come into the existence. It is the Mohammedan law. Is it correct? Yes, it is. So next question. That is the 7th question. In which chapter criminal conspiracy appeared or mentioned in the IPC?
3, sir.
Yes. First option, chapter 5.
capital
Second
A.
option, chapter 5, small a. Third option, chapter 5, capital A. And fourth option, chapter 5, capital B.
Third one.
It is the third one is the right answer.
Yes.
Chapter 5, that is the Roman 5, capital A. And there the criminal conspiracy was appeared. Next question is, which section of the IPC deals about the criminal conspiracy? Number 1, section 120 to 121. Number 2, section 120 small a to 120 small b. Section third option, section 120 to 121. And the fourth option, section 120 capital A to 120
one,
capital
sir.
B.
Section 120 capital A to 120 capital B.
That is the right answer. Section 120 capital A to section 120 B capital B is the right answer. And the 9th question, offenses affecting the human body. I repeat, offenses affecting the human body appeared under dash of the IPC. Chapter 15, chapter 16, and chapter 16 Roman, chapter 15 Roman.
16, sir. Chapter 16.
What is the option? 2 or 3? Or
3.
3 is the option. Chapter
Three.
Roman 15, 16 you have to say. Chapter Roman 16, that is the IPC. The feedback I have given, section 299 to 377 of the offenses affecting the human body is drafted in the Penal Code of Indian Penal Code. Yes, 10th question. The gravest one is virgule or not hurt under the IPC. It's a not hurt under the IPC. The gravest one are not hurt under the IPC. Number 1, assault. Number 2, murder. Number 3, kidnapping. Number 4, rape. Other 3 are gravest hurt under the IPC. Only one is not the greatest hurt.
Kidnapping.
The gravest. Yes?
Kidnapping.
No, kidnapping is the gravest hurt.
Number 1.
Number 1,
Assault, sir.
assault is a simple injury, simple hurt. Assault is a simple hurt, it is not a gravest one. But the rest of the 3, murder, kidnapping and rape, it are said to be the gravest hurt under the penal code. So that is the answer, is the number 1 for the 10th one. Next, 11th question. The offenses that are dealt in the IPC include, among others, theft, extortion, robbery, dacoity, cheating, and forgery come under the caption. In which caption it will come? In which umbrella it will come? Number 1, crime against the human body. Number 2, crime against the state. Number 3, crime against the property. Number 4, crime against the public tranquility.
It's 1, sir.
Wrong. It is not the answer. Wrong. Crime against the human body is different.
It's a criminal
one,
against
sir.
the
Fourth,
state
sir.
only, sir.
Forgery,
crime against the
cheating,
state.
dacoity, robbery, extortion, theft.
It's a 2, sir. I think crime against the state only.
No, crime against the state is a rebellism, making a wage war against the state, making the insurgent. That is the crime against the state.
Okay.
See, what property would be theft? What property would be the extortion? It's a crime
it's a
against the
public
property.
only, sir.
Number 3 is the right answer. Because theft, extortion, robbery, dacoity, what you do? Property. So it's a crime against the property. That is the 11th question. Is it clear?
Yeah, I understand, sir. Yeah.
Okay, next question. Yes, anyone can unmute and read the next question? That is the 12th one. Unmute and read. This one which I highlighted. Anyone? Unmute and read.
Chapter 6, which deals with offense of the nature and includes the sections, are some of the most rigorous penal provisions of the entire IPC. It's 1 is 120 to 130, 121 to 130, 122 to 131, 129 to 129. It's showing
No, actually,
121 to 130, sir.
It's
The second one.
121. It's 121
Second.
to 129. Okay.
130, yes.
It is, the answer is
Second
one, 121 to 130. It deals with the nature and includes sections, and it is the most rigorous penal provisions of the entire IPC. It is a waging against the war against the state, rebellion against the state, insurgent against the state. So these are the things which come under it. 13th question, which is not come under the general exceptions. Number 1, consent. Number 2, insanity. Number 3, emergency. Number 4, necessity.
Consent, 1.
No.
No.
I say which is not
which is
come under
not
the
come
general
under the general
exceptions.
exception. Insanity will come,
Come
sir.
under the general
Necessity,
exception.
emergency also will come.
No, there is no word emergency. It is necessity.
Which is not come under the general
There is
exception.
no word in the general exceptions emergency. Consent
Yes.
comes, insanity comes, necessity comes, but there is no word emergency in. But we
Emergency.
word the necessity is there. And feedback I will read it. General exceptions. Section 76. Supplementary question also they may ask. 76 to 106 of the chapter Roman 4. See, when you are reading, please read in this way. Say chapter 4, Roman 4 you should say. Don't say merely 4. So embody the general exceptions, which are exceptional circumstances where the offender can escape criminal liability. A basic example in this context is the right of the private defense, that is section 96 to 106. Other concepts that are elaborated upon in the chapter include insanity, necessity, consent, and act of the children below a certain age. Yes, they come under the general exceptions, but there is no word emergency is there. 14th question. Note, yes, in which case law Supreme Court of India decided unnatural offenses are not crimes, like sodomy, homosexuality. Number 1, Navtej Rawat Johar versus Union of India. Number 2, Navtej Singh Kaur versus Union of India. Number 3, Navtej Singh Johar versus Union of India. Number 4, Netaji Singh Johar versus Union of India.
Third one, sir.
It is the third one in the right stance. Navtej Singh Johar
Navtej Singh
versus
Johar versus
Union of India. Homosexuality is not a crime. So sodomy is not a crime. They say unnatural offenses. The court was asked to determine the
Large foundation is
constitutionality of
also there
the
now, sir.
section 377, that is the unnatural offenses of the Indian Penal Code, a colonial area law which, among the other things, criminalized the Homosexuality Act as an unnatural offense. It is dealt in the Navtej Singh Johar versus Union of India. So supplementary question also asked, what is the unnatural offenses come under the Indian Penal Code? Then the answer is, it is the section 377 comes under the unnatural offenses. So 15th question. There is the presumption of severe stress on a person who attempted suicide, and such a person is not to be punished under dash IPC. It is nothing but euthanasia, killing himself. Option section 307, second option section 308, third option section 309, and fourth option section 310.
309.
It is a 309. Generally, it will be there, but in the yes, it is nothing but euthanasia, killing themselves because they cannot tolerate the pain and suffering, and they will be leading a life of a vegetative state, and hence they ask the doctors to administer something where they can kill themselves. So in certain cases it will be the exception, otherwise it will not be an exception. It is also amount to a culpable homicide, not amount to murder, if I not be mistaken. Yes, 16th question. Adultery is no more crime was decided by the Supreme Court of India in the case of number 1, Joseph Shine versus Union of India. Number 2, Joseph Shine versus State of Kerala. Number 3, Joseph Sinde versus Union of India. Number 4, Joseph Shruti versus Union of India.
One, sir. One. Joseph
It
Jain
is the
versus Union of
one.
India.
It is the Joseph Swine versus Union of India. That is the right answer for the 16th question. Now let us go, because the feedback is adultery comes under the 497. The section which criminalized and prescribed the punishment was criticized for treating a woman as a private property of her husband and imposing a moral principles on a married couples. This section was finally struck down by the Supreme Court in the September 2018 while disposing the case of Joseph Shine versus Union of India. 17th question. Can anyone unmute and read? Can anyone unmute and read 17th question?
The nature of an Indian Penal Code has been highlighted as one of the employer and employee, principal and agent, landlord and tenant, master and the servant.
These are the four options. The Indian Penal Code has been highlighted as that one, either the employer and employee, or principal and agent, or landlord and tenant, or master and servant. Answer is master and servant. Let us see the feedback. The nature of the Indian Penal Code has been highlighted as that one of the master and servant, with some of the provisions having no place in independent India. Some of the section has need reforms and review as follows. A supplementary question. Which sections need the reforms and review? Supplementary question. At that instance, a re-examination of the sedition law, yes, inserted in the 1898, it should be removed. Of course, it is removed also. The offense of the blasphemy should also no place in the liberal democracy, and therefore there is a need to repeal the 295 capital A, which was inserted in the 1927. Yes, it also be needed repealed. Next, a criminal conspiracy was made substantive offense in the 1913. The offense is objectionable because it was added to the code by the colonial authorities to deal with political conspiracy. That also will be supposed to be repealed. Under section 149 of the Unlawful Assembly, the principle of the constructive liability is pushed to unduly harsh length. Yes, that also need to be repealed. The sexual offenses under the code reveal patriarchal values and outdated Victorian morality, and though the outmoded crime of the adultery gives the husband the sole proprietary rights over his wife's sexuality, it gives no legal protection to secure a similar monopoly over the husband's sexuality. These are the things which need to be reviewed and repealed under the Penal Code, because it is made at the colonial time. Next, anyone can unmute and read the 18th question? Anyone?
The father of Indian modern legal education.
Read loudly.
Who
Loudly.
is the father of Indian modern legal education? N.R. Madhava Menon, R.N. Madhava Menon, Upender Bakshi, J.N. Mishra.
Who is the father of the Indian modern legal education? 18th question. Number 1, N.R. Madhava Menon. Number 2, R.N. Madhava Menon. Number 3, Upendra Bakshi. Number 4, J.N. Mishra.
Madhava Menon, sir.
See, which Madhava Menon? Number 1, number 2. It is number 1 is the right answer. Of course, Madhava Menon is died, I think last year, if I not be mistaken. But he is the brainchild of the NLSUI Bangalore. And it is his efforts, the NLSUI Bangalore was made. And later on, there is a judicial academy there in the Bengal, also because of his brainchild. So, Dr. Neelakantha Ramakrishna Madhava Menon is said to be the father of Indian modern legal education. And he wrote the many books. Among them, the clinical law is a very famous book. Of course, other books are also very, and he is no more now. So, 19th question. How many genders are recognized in India? 1, 2,
Three, sir.
two, three.
Three, sir.
3,
Three.
4, 4, 5. Who are they?
Three.
What are they?
Male, female, and third gender.
Transgender.
Transgender.
Yeah,
That is the
third
word
gender
that
we
you
will
have
say.
to use
Sir.
it. I am going to ask, which is the case law about the transgender? That I am going to
Nas
ask.
Foundation.
Yes.
Nas Foundation case, sir.
What is the transgender case law?
Naj Foundation
No.
versus
It is the National Legal Service Authority versus Union of India, and where a NGO organization of the transgender with the National Legal Service Authority joined together. They challenged it because they are discriminated, and that is the reason they fight it against the Article 14, 21, and 19. Of course, these are the articles they made it, and the Supreme Court has given the judgment, yes, they should not be discriminated, and it will be that 3 genders are there now available: he, she, and transgender. So total 3. So now Indian passport application forms were updated with 3 genders. Option M, F, and E. What is the full form of it? Number 1, for mother, father, and eunuch respectively. Number 2, for mother-in-law, father-in-law, and early boys respectively. Number 3, for male, female, and eunuch respectively. And number 4, it is not 3. Number 4, for male, father, and eunuch respectively. Which one is the correct full form of M, F, and E in the passport?
Option 3.
Yes?
Fourth one.
Option
Repeat.
3.
M stands for male, F stands for female, and E stands for eunuch respectively. Then which is the right answer among the 4?
Option 3.
Which is the right answer among the 4?
Option 3, sir.
It is third, 3. For male, female, and eunuch respectively. That is the third is the right answer for the question 20. Next, feedback. It is your society's problem that you only recognize 2 sexes. Hijra, that means eunuch. Social movements have campaigned for recognition as a third sex, and in 2005, Indian passport application forms were updated with 3 gender options: M, F, and E. That is for male, female, and eunuch. Eunuch means hijra. Hijra will say no, chekka. So now the 25th question. Can anyone unmute and read? Yes, anyone can unmute and read.
What is the decisions of the landmark judgment in Nalsa versus Union of India deals with? A woman cannot enter into Sabarimalai temple, love jihad, transgender and intersex persons, adultery. This one is third one is answer, sir. Transgenders and intersex.
Because I already referred the case law there. National,
Yes, Nalsa.
that
Just
is
now you said, yeah.
Service Authority versus Union of India. It deals with the
Yes,
transgender and intersex persons. So that is the case law. And the Supreme Court had affirmed in its landmark judgment, Nalsa versus Union of India, that transgender and intersex persons have a constitutional right to self-identity as a male, female, or transgender without medical intervention. Okay, now, 22nd question. Voyeurism is a dash, the court reminded. Number 1, criminal offense. Number 2, not criminal offense. Number 3, adultery. Number 4, sodomy.
One, sir. One criminal offense only.
It is a
Section
criminal offense.
354C.
What is meant by voyeurism?
secret observation of women without her knowledge.
Yes, is a secret observation of the woman naked body, either in the sex or by any other changing the dress.
Any other forms?
Yes. So that is called voyeurism. Okay, next
Good evening.
is,
Is Ravindra Babu sir from Vijayawada.
okay. Oh, welcome, sir. Karibu sana.
Sir.
You are welcome to the class. Yes.
సార్ మీ ఇమేజ్ టాప్ రైట్ కి మూవ్ చేస్తే కొంచెం బెటర్ గా అనిపిస్తుంది సార్.
ఏంటండి?
మీ ఇమేజ్ ఉంది కదా, బాటమ్ లెఫ్ట్ లో ఇమేజ్ ఉంది కదా, మీ ఐకాన్ అది మూవ్ చేసే ఫెసిలిటీ ఉంటే
I did not keep my image.
అది ఆటోమేటిక్ గా ఉంటుంది. మౌస్ తో ట్రై చేయండి సార్, డ్రాగ్ చేసి పైకి టాప్ రైట్ కి.
అది because I could not see it, my image. You could see my image.
మీకు కనిపించట్లేదు సార్. ఓకే.
I could not see my image. Suppose ఇది స్టార్ట్ చేసిన అనుకోండి, now you could not see my photo. You see my video, my face directly.
మీ వీడియో కనిపిస్తుంది. మీ వీడియో లొకేషన్ మాకు బాటమ్ లెఫ్ట్ లో కనిపిస్తుంది సార్ స్క్రీన్ లో. టాప్ రైట్
రాకుండా చూస్తున్నా. I made it not to become a disturbance to you. Moreover, I am not using the video because
వీడియో అయినా ఫోటో అయినా పెద్ద డిఫరెన్స్ ఏం లేదు. అది సైజ్ అదే ఉంది. మీ టాప్ రైట్ కి మూవ్ అయితే ఎక్కువ టెక్స్ట్ కవర్ అవుతుంది సార్. అది మూవ్ అయితే ఆ బాక్స్ లాగా ఉంది కదా, ఫోటో ఆర్ వీడియో.
I cannot move it, that is because I could not see it. I could not see that thing. ఎందుకంటే the reason is I am sharing the screen and hence I could not see it.
Okay sir.
Okay. So now the 23rd question is, Supreme Court recognized sex work or a prostitution as a dash. Number 1, practice. Number 2, license. Number 3, profession. Number 4, not a profession.
Professional, sir.
It is a profession. Either sex or sex work or prostitution, they have now said it is a profession. So number 3 is the right answer. Can you tell me in which case law it is decided? Because I tried my level best, but only the thing they are saying, sex workers filed a case against the Union of India. They are said like that only. But anyway, that I use the same terminology. Prostitution is not a crime or offense, but running the brothel is dash. Is a profession, not an offense or a crime, or an offense or a crime, or only 1 and 2.
It's the third one, sir. An offense and crime also.
It is an offense as well as the crime. But prostitution is not a crime or unlawful, but the brothel running is a unlawful and a crime. Yes, next, I believe that everybody knows the brothel, where the prostitution will be running over there in a place, a house, or a corner, or a enclosure place. So 25th question, prostitution.
They have an act on women trafficking, sir. Women trafficking.
Yeah, Women Trafficking Act also, it will say about it.
Yes.
You are right. 25th question is, prostitution is a profession to be included now under number 1, 19(1)(d), number 2, 19(1)(e), number 3, 19(1)(g), number 4, 19(1)(h). Yes, out of 4. See, we already know that the profession is there in the fundamental rights. That comes under the 19(1)(g). 19(1)(g).
To practice any profession or planning any occupation. Trade or
There
business
is a possibility of the making, because they say now, Supreme Court, it is a profession, and a profession comes under the G. Please check it whether I am right or not.
Correct, sir.
Yes. 26th question. What is the name of the case law where Supreme Court have given the judgment that sex or prostitution is a profession lawful, but running the brothel is unlawful, decided in the case of? Because I searched everything, but I found only sex workers filed a case against the Union of India. So right answer is? What is the right answer?
Sex workers versus Union of India, I think so.
Yes, it's sex workers versus Union of India. That will be the only the thing, as far my knowledge goes. And it's 27th question. Which one is not connected with the prostitution or sex workers among the following 4 cases? Here I maintained the 4 cases, but one is not connected to the prostitution or sex workers. Number 1, Kajal Mukesh Singh versus State of Maharashtra. Number 2, Unni Krishnan versus State of Andhra Pradesh. Number 3, Manoj Shah versus State of West Bengal. Number 4, Buddhadev Karmaskar versus State of West Bengal. One is not related to the prostitution or the sex workers, but the 3 are related to the prostitution and the sex workers. Yes, make a trial. Kajal Mukesh Singh is the sex. Unni Krishnan is not the state of, is not there. Because Kajal Singh versus State of Maharashtra, there is a 2021, the Bombay High Court said, prostitution is not an offense. A woman has a right to choose her vocation. Vocation. In Manoj Shah versus State of West Bengal, that is a 2003, the Calcutta High Court observed that sex workers should be treated as the victims of the crime rather than the accused. So that is the decision given over there. And the next is Buddhadev versus Karmaskar. Buddhadev Karmaskar versus State of West Bengal, 2011. The High Court observed that sex workers are also entitled to live a dignified life as a guaranteed under the Article 21 of the Constitution. But Unni Krishnan versus State of Andhra Pradesh, it is a summary of the cases. The case involved a challenge by certain private professional educational facilities to the constitutionality of the state laws regulating the capitation fee charged by such a institution. If the capitation fee is case law, not related to the prostitution or the sex workers case. Yes, 28 question. Can anyone unmute and read? The 28th
Which
question.
section of IPC deals about sedition? Section 123, Section 124, Section 124A, capital A, Section 124, capital B. Third one is answers, Section 124A.
Is it correct answer? It is a section 124 capital A is the right answer for the sedition. Of course, it is repealed. So feedback
This is
is,
recent, the Supreme Court.
yeah. The law of sedition was introduced by the section 124 capital A of the IPC as a draconian measure to counter anti-colonial sentiments, and most major leaders of the independence movement, including the Gandhi and Tilak, were tried under this provision. Gandhi famously described section 124A as the prince among the political section of the Indian Penal Code designated to suppress the liberty of the citizen. There are many supplementary questions also, you will get it from here. Because what is the,
Sir,
what the
then-
Gandhi said about the section 124A?
Yeah,
Yes,
sir, we need
somebody
to talk in
speaking.
Constitution
Pandaraga,
1918.
Pandaraga, mute it. Because whatever you speak, I could hear you. When I say unmute and read, at the time you read, otherwise you have to mute it. And whatever you speak, I could hear you very clearly. So coming back, when the Constitution Assembly deliberated on the scope and extent of the restriction that could be placed on the free speech, the prominent exclusion from what eventually became the Article 19, Sub-Article 2 was the word sedition in the original draft that was up for the discussion. The word sedition has been included as one of the grounds for the restrictions on the speech. So that's why now it is no more in the IPC. The 29th question is, what is the act number of the IPC in 1860? Is it number 1, 42? Is it 43? Is it 44? Is it 45? Act number I am speaking. Act for every year there are Act 1, Act 2, Act 3. They will number it till the 31st December. The next year again it will start with Act number 1 the next year. So what is the Act number of the IPC? among the four options? Anyone? Unmute and give me the answer. It is the Act number 4, that is the 45. It is the Act in the 1860, it is the 45 serial number of the Act which is made over there. And hence the answer is Act number 45 is the right answer. Now the feedback, let us see. The Indian Penal Code IPC is the official criminal code of India. It is a comprehensive code intended to cover all substantive aspects of the criminal law. Indian Penal Code, the Indian Penal Code 1860 and Citation Act number is 45 of the 1860. Are you hearing me? Say yes. Are you hearing me?
Yes, sir. Yes, sir.
Yes, sir.
Yes. Here I read the word IPC. IPC, whether what type of the abbreviation it is. Because there are total 4 type of the abbreviations are there. Number 1, initialism. Number 2, acronym. Number 3, shortening. Number 4, contraction. These are the 4 varieties in the abbreviation. IPC comes under which category? Anyone? I repeat the question. Abbreviations are divided into 4 categories. Number 1, initialism. Number 2, acronym. Number 3, shortening. Number 4, contraction. And IPC comes under which category? Did you understand my question? Did you understand my question? I repeat. Did you understand my question? I did not get the answer from you.
Yes, sir. Question is understood, sir.
See, initialism means we don't combine the all words and pronounce like a one, like a USA. That means you pronounce the U separately, S separately, A separately. So when you pronounce the each word separately, we will say it is a initialism. And here IPC is a initialism. But acronym, we will say that extent, NATO, OPAC, CAFEPOSA. We will pronounce all words in a one word form. And that is called acronym. And shortening means February. And we don't write full spelling of the February. We write the capital F, E, small e, B, full stop. That is the shortening. And the means, suppose if you want to write I will not. We don't write I space WILL and space NOT not. No. At that instance, we write I WIL apostrophe T. That is called contraction. Is it clear? I don't know whether you got my point or not. Is it clear? I will show you that.
Yes, sir.
Sir, clear, sir.
Yeah. See, here I am showing you. I think you could see it now. Abbreviation. Could you read it now? Yes? Could you read it now? Is it visible?
Yes, sir. It's visible.
So I showed you initialism, URL, Uniform Resource Locator, or SMS,
Locator.
Short Message Service, acronym, SADC, Southern African Development Community, shortening, F, capital F, EB, for the full form is February, contraction, I will, the I apostrophe LL, that means I will. There are the 4 types of the abbreviations, and we will say the initialism, acronym, and shortening and contraction. So this, because we got the chance to explain you, and hence I made it. Okay, next is, here I said it is a 45 Act, then we can say it. And the last question is, the offense bigamy is dealt under the IPC. Which section?
494, sir.
Yes, you are right. It's a 194. What is meant by bigamy?
Marrying again, whether it's in the lifetime, sir, of husband or wife. Husband is there or wife is there. If he's marrying a second marriage, if
Yes, that is called
without
bigamy.
having a divorce, with the person is alive, then he cannot marry the second person. Then it is called bigamy.
Unless you take a divorce completely.
Divorce, yes.
Or you cannot marry also when the divorce proceedings are in the court.
Exactly.
Yeah, even that thing also. So these are the 30 questions today I made in the penal code, and they can ask you from anywhere. But what I am trying to make you to know, I want to train to make you to how we can pursue it. I want to make you the logic, how we can make it the mindset. So I'm setting your mindset in a such a way, if you don't know the answer also, but you can apply the logic and you can use it and you can tick it, and I'm sure that it will be successful. So in any nook and corner, they may ask the question, but I took only few of them here for your understanding. But if you happen to see my old videos, yes, I cover the different manner and differently and different question, and very less possibility would be there where I made a repetition. If I made a repetition also, the style of asking is a different angle. So that is the thing which I want to make it out. And tomorrow, because at any time it will stop, because time is going to up, only 1 or 2 minutes are there. And here I started yesterday, and the first one I did the constitutional law of India. The second day, today is the IPC, Indian Penal Code, and the third day it is come the CRPC, if I not be mistaken. That is the Criminal Procedure Code tomorrow. But the tomorrow class, as usual, from 6:10 to 7, not like today 8:10 to 9 o'clock. Is it clear? So before you are coming to the class, better you read and come and participate in the class. That will be a good idea, rather than without replying and just keeping quiet will not be there. If you make a hunch, if you did not know it also, sometimes your hunch may really hit the target. So you can use such a logic and you can make it out, but definitely say, otherwise there is no negative marks in this examination. If the negative marks would be there, people will pass like a UPPS only. So negative marks are not there, hence you can try it and don't leave any question blank. So with this, I would like to stop it today. If you want to ask anything, you can ask, because it can stop at any moment. Because it is approaching to the nearly. Anything that you would like to ask me? Yes? Participants, do you want to ask any question to me? I don't know whether you are hearing me or not, because I did not get the reply from you.
No, sir.
So something should have to speak. You unmute and speak. Otherwise, I don't know. I'm speaking to the wall. It gives the sense to me. Unless if there is a reply from you, that means I am with you and you are with me. That gives the sense to me. So now I will stop it, because even though I don't stop it, it automatically stops over there. But anyway, bye, and we'll see you tomorrow at the as usual timings. And up to that extent, thank you very much for patience listening to me.